for the individual litigant, but it's a victory for the Constitution. This is another major decision upholding our constitutional provisions. The time for, resorting to the rule of law should now actually be welcomed, because the Constitution is there. That is what constitutional democracy stands for. In a constitutional democracy, you are ruled by the rule of law and not by the rule of might. Therefore, where there is a clear provision as to what should be done, as in this case, if you defect from one political party to another, honorably vacate your seat so that another election can be conducted. But in this case, that is not what has been happening. So this is a major victory for our Constitution. Remember that this same situation was faced by the Supreme Court in Abegunde's case, and they held along the same line as we have just heard this afternoon. So this is a victory for the Constitution. Thank you very much. Okay.
Yeah, good afternoon. It's the view of the judge that the legislator's defection was improper in law and that they should conduct another election to fill vacancies. But like I told His Lordship, I humbly and respectfully disagree with the judgment. There were some major areas of the pleadings that His Lordship did not touch at all. For example, the defendants in this matter, the legislators, tendered hard evidence in terms of letters of expulsion by the PDP as a political party due to the schism and crisis at the national level of the party, saying they were expelled from the political party and that they did not defect. You can only defect from a party in which you are a member. But where you have already been expelled, it becomes your constitutional right under Section 40 to exercise your freedom of association and freedom of assembly by going to any political party of your choice. So they could also have gone to Labour Party, Zenith Labour Party. They could also have gone to any other political party in Nigeria like Abga. You can't expel a person and say his political career should terminate and be moribund. This aspect, this critical aspect of the case was not touched at all by the judge. He just said they tried to pull a wool. What wool? There was no counter affidavit controverting these hardcore facts that we were no longer members of the PDP and that we did not defect, but only went to another political party of our choice after we had been expelled. Because there was no reference to it at all, it shows that the very mainstay of this case was not looked into. We also noticed that the issue of the crisis at the national level of the party, which we put in our affidavit very copiously, such that the former national chairman had to go up to Court of Appeal in Port Harcourt, Prince Uche Secondus, and that up to now he is even at the Supreme Court, and that the last convention of the PDP actually held without his consent, without his being physically there. All these issues were not looked at all. So even if we were to talk about the division within the political party going by Abegunde's case, using Section 68, subsection 1G, there is enough evidence that there was division at the national level. But our case is stronger because the defendants were no longer members of the PDP, and you cannot defect from a party in which you are not a member. The other point also that we also disagree with is that the entire dramatic personnel in this matter, all the people who were said to have defected, all the actions took place in Calabar, in Cross River State. The defection, their election, their election, the dismissal or expulsion, all of them took place in Calabar, where you have the PDP and the APC. So, question, what are we doing at the Federal High Court, Abuja here? The proper forum, not just territorially, but also going by the practice directives of the Chief Judge of the Federal High Court, is that a matter should be filed where the cause of action arose. Where did the cause of action in this matter arise? Was the expulsion done in Abuja? No. Were they elected in Abuja? No. Was the crisis affecting them at the national level, which now dovetailed to affect them at the local level to the extent that they were spared? Was it in Abuja here or in Calabar? Everything was in Calabar. So question is, what are we doing here? I believe that the court ought to have transferred this matter to the Calabar Judicial Division of the Federal High Court. There are so many other reasons. So, like I told the judge, in law, we have 90 days under Section 25A of the Court of Appeal Act to appeal to the Court of Appeal. 90 days. And this being a final judgment under Section 150 and Section 151 of the Constitution, we don't need the leave of the court to appeal. It's an appeal as of right. But I can assure you that we will file a notice of appeal today. The registry is still open. It's still opened even as I talk. We're already hammering it. As the judgment was going on, we were preparing a notice of appeal contemporaneously. And we will file it in the next 30 minutes so that the world will see that this is a case that cannot stand.